Just a minute.
Yeah. Okay.
Just a minute. Yes, now we are live. Please start.
Okay. Good afternoon, ladies and gentlemen. I welcome you all to the first live webinar on IP litigation. The guest lecturer for the session is Ms. Akshata M. Patel, a grad from NUSRL Ranchi and a former associate at Hola and Associates. Today we also have Dr. Srinivas Murthy, who is an associate professor at NUSRL Ranchi. Now, without any further delay, considering we have already delayed for a total of 5 minutes, I shall request Akshata ma'am to proceed with the session and deliver her lecture on the topic IP litigation. Ma'am, if you can kindly proceed with the same.
Uh, Thank you, Pritesh, for starting the session. Okay, today we will be focusing the session on the scenario of litigation, specifically in the field of intellectual property laws in India. How we'll be do a comparative analysis of our current laws, developments, how are the courts from the district level to the high court and the supreme court, how are the judges interpreting the laws, what are the advancement in comparison to our western counterparts. So these are some of the things that we will be focusing on in this session. Also, I would like to give some practical insight because our prospective audience mostly are students who are very interested and passionate about the intellectual property laws that are developing in India. It's actually a niche subject which is picking up among the youth, currently law students in India. So I would like to keep it focused on that aspect. So I'll be sharing a PPT for the presentation. Yeah. IP litigation in India few years ago was very fragmented and jurisdictional. Like for instance, we all know that there is a side of IP litigation. Before IP litigations comes IP prosecution, which was only limited to jurisdictions like Delhi, Kolkata, Mumbai, Chennai, because of the presence of the IP offices there. And a lot of IP professionals were scattered in and around these jurisdictions, providing assistance to clients only in these high courts or district courts. But there is a slow change in that traditional route we have seen. Other states, other jurisdictions are coming up with the need for IP enforcement in their local jurisdictions to protect their businesses, to protect the interests of the artists and other forms of entities. Before we begin the before we focus on the intellectual property rights litigation in India, let us see the basic forms of intellectual property rights that we see: that trademark, copyright, there is patent litigation, there is design litigation, geographical indication, semiconductors. So although semiconductors, plant varieties act and patent litigation is very very less in India. If we look at our western counterparts like United States of America, the EU litigation practices, we see that the number of litigation cases there, the number of entities who protect their IP there is very very high in comparison to the Indian trials situation here. However, we have seen a great number of uh, rise in the trademark disputes and the copyright disputes. The procedure we follow for litigation is similar to the civil procedure that we follow for any other civil dispute in India, if we are focusing on the civil prosecution. Now, if we look at the criminal cases, if we are looking at a violation of copyright, if we are looking at a violation of counterfeit products, all of them fall into the domain of you can either go for a criminal prosecution or either you can go for a civil prosecution. Criminal, it is straightforward: you file an FIR, uh, uh, the uh, the police will take the action from there, they will investigate it, raid will follow if there is a investigation. and then the case is booked, the magistrate will take up from there, and it is prosecuted. That is the criminal side of the prosecution. In this case, I will be focusing on the civil disputes, how we handle intellectual property disputes from the district courts, because as we all know, the provisions are very specific. Any dispute regarding trademark, copyright, all of them starts at the forum. The lowest forum you can file the case is in the district forum of that particular jurisdiction. Currently, in states like Delhi, the High Court itself has an original bench, that is original jurisdiction. You can go there and file the cases directly there. But when we look at Bangalore, there are some cases where in Bangalore we have a special court that is set aside in the district court for intellectual property rights litigations. So each state has its own practice set up, but all in all, the procedure that you follow to prosecute the case is similar. Now, if a prospective clients come to us and tell that I have been using the name Tej Kamal for running my company since 2009, now an ex-employee of mine has gone ahead and opened up another company in the same sales that I was doing. That is, I was selling certain pipes in the industry, and my ex-employee has set up the same name and is selling, and he's stealing my customers. Now, what do you do in this situation? Where comes in the part of enforcing the rights of your client? So when they come to us, what is the first thing that we do? We check that do they have the right to first prosecute? Is the trade name that they say that they own, is it theirs? Is it a common name in the industry? Is other traders in the industry who sell pipes in India also use the name trademark? So first we make sure that our clients name rights, trademark, or if they come up with a copyright, or if they come up with any other issue. So we check the proprietorship. Are they the owners? First, you'll have to own the right to execute the right. So first check that we do is that. And then we proceed with coming up with various ways. Do we have to go ahead with the criminal case? What are the advantages of having a swift criminal action, or what are the advantages of going for a civil action? If we go for a civil case, we just don't get injunction. We can ask for a prayer of damages. So that is one of the advantages of going for a civil litigation. When we file a civil case, we can open up the investigation. We can ask for the profit and accounts of the infringer. We can ask for the damages to be calculated based on the profit and loss. We can even get a court commissioner appointed through a civil case itself to make sure that the counterfeit products or an infringing pirated products in the market or any form of IP that is being violated is swiftly taken care of by various forms of injunctions. So we have to decide when a client comes up to us with a violation of their intellectual property rights. We have to set up a plan to see which is the best course of action, which is the most feasible course of action. Because as we know, that a lot of sales is not just limited to one jurisdiction, or a lot of services offered by businessmen or other individuals will not be just limited to one jurisdiction. It will be widespread all over India. Now, if our client has to take action against infringers every nook and corner, it can be very exhaustive, and they might not, all businessmen may not be equipped to deal with such an extensive legal plan that we might lay out. So which is why you'll have to tailor make your plan of action for them, see how the law can benefit in making a swift and quick justice for the to protect their intellectual property rights in the market. Then we issue a season. It begins with a cease and desist notice. There is no mandatory law saying that you'll have to issue a legal notice to go ahead with it. It's sometime. I think there's a question. Hello. Pritesh, is this?
Your slides are visible.
Is my audio correct? It's going on?
Yes, ma'am. Everything is perfect. Just the slides were not.
So, so then we issue a cease and desist notice. Therein, the process begins. So, one of the advantages of issuing a legal notice is if it is a small businessman or if it is a see, there are different kind of violators in the market. I'll give an example as to what kind of violators are there. So there are some violators who are aware of their reputation of a very good brand and they adopt a similar name, or they're violating any other intellectual property knowingly with motivation to make profit out of the violation of that in particular intellectual property rights. It can be copyright, it can be patent, or it can be a design. So these violators to take commercial advantage of another asset, IP asset, they go ahead and intentionally violate it. For such violators, a league cease and desist notice might not be quite effective in nature. Or rather, if we issue a cease and desist notice, the violator can get alert. The violator can make sure that we do not get any form of injunction from the court of law by filing caveats, being aware, trying to take advantage of the benefits of law, take advantages of some of the loopholes that are present in the law. So the intentional or motivational willful violators can take advantage of a cease and desist notice. So you'll have to even look at the prospective violator before issuing a cease and desist notice. So if there are some people, there might be a very famous actor name or trade name that he will be doing. So as a fan, as a show, to show a fandom, they might have adopted that trademark, or they might have used their copyright, or they might have violated it not in to make profit out of it, but out of ignorance. So such violations can be handled with a cease and desist notice. So before you go ahead and issue a cease and desist notice for any form of intellectual property violation, study the prospective violator first, would be my suggestion. Then you can move on to the stage of negotiation, wherein you can negotiate, see if it works out. See, despite how a lot of litigants, advocates, judicial system try to give speedy recovery for the aggrieved, the system is overburdened. The procedure is exhaustive, but it makes sure that the checks and bounces there before a final judgment is passed against the aggrieved. So a lot of procedures that has to be followed in the court of law can sometimes delay the justice that is impending. So because of this delay, a lot of businesses or intellectual property owners prefer not to go for the mode of enforcement through litigation. They try to go for alternative disputes, negotiations, which can also be checked. But like I said, it depends on the nature of the violators and the nature of the violation, the commercial value at stake. Then we go ahead with the drafting and the case is filed. The procedure we follow will is in India currently for violations of trademark infringement suits or passing of actions or copyright infringement suits, patent infringement suits is a CPC. We follow the civil procedure code. The filings are similar. You go ahead and file. So one stage that is very important in an IP litigation is an ex parte ad interim injunction that is sought by the plaintiff. When the aggrieved IP owner goes for his enforcement of rights before the court of law, he can go ahead and ask the court for an injunction against the defendant without giving notice to the defendant. If the case is has a very strong prima facie face value. Prima facie value, when we say this prima facie value, meaning he has a clear title over his IP right and he has irreparable loss that might come out of such violation, if he can clearly establish a balance of convenience in his favor, if these three main trinity can be established before the law, the court, without even giving the notice to the defendant, can issue an ex parte injunction. What does an ex parte injunction mean? Let us take, for example, I am using the term, I'm a proprietor who you have under the brand. Let us say Nike wants to take an action against some of the violators of its brand. The famous tick mark is being used on other apparels in the market. Now, what will Nike do is Nike will go to the court, and it is such a well known and a well established brand. If they can prove it before the court that the violator has adopted a similar mark, see, if a shoes in the market is currently being sold with the just the tick mark, it is a clear violation of the rights of the Nike brand, because the brand is quite popular. Their proprietorship is established in the market already. It is a well-known brand. So, if you can prove that before the court with sufficient evidence and documentations and your trademark registration certificates, what happens then is the court sees that there is a prima facie case, and irreparable loss can also be proved here. Why, like I spoke of, irreparable loss is a loss that cannot be compensated in terms of money. Now, if a loss can happen to the brand and the goodwill and the reputation that Nike has built by the third party person selling a less quality apparel in the market on its own brand, it will have an impact on its goodwill in the long term. So, this is an example of an irreparable loss. If this is clearly established before the court, even before sending a notice to the defendant, can say issue an order stating that the person has to stop selling those products under that famous tick logo. The minute the court orders, the notice has to be issued, the procedure has to be followed before the court, and the notice has to be sent to the defendant. He will of course have an opportunity to come before the court, put forward his case, have the injunction vacated if there is any other discrepancy in the or misrepresentation on behalf of plaintiff. The process is there, but the minute the order is passed, he has to stop the production, he has to stop selling it under that trademark. So that is how effective an ex parte ad interim injunction is in a IP litigation specifically. It can decide a case or make a case very fast, because if there is a strong suit, if they'll have, sometimes if he's just opened up his business to sell such counterfeit products, you can put an immediate stop to that business and have it shut down. So this is how an effective and ex parte ad interim injunction is. Now, if this is just an example of a trademark case, now if we look at a copyright infringement, I might be the original author, composer, or a producer of a musical product recording. Now, I have the proprietorship rights over it completely. My title is clear. I go to the court saying that someone else is remaking these songs, reselling them without my permission, authorization, and commercially exploiting it. Then the court, the quantum that the court will observe is, first again they'll see if you have a prima facie before or giving you an injunction to stop the sales of those sound recordings. First they'll check whether you have a title over your right, and if there is a substantial recreation of that, how much song is being violated, which how much to cause a violation, is it just a mere 2 second tune? So all of, is this a substantially, if it is being used or not, all of this will be considered by the court, if we look at a copyright infringement suit. When all of this, after consideration of all of these, the court will pass an ex parte injunction. Now, similarly, there are different minor variations in a design in a suit that disputes or violations of your patents. If it is a violation of your patent, first they'll look at your grant certificates. If there has been a prior publication, is it valid? So all of this will be considered by the court before going ahead and passing an ex parte ad interim injunction. The court has to provide reasonings for the order because it is that effective. Going from this stage again, once they come on record, before the court. They will argue. So these are the main stage that usually currently in the Indian litigation practice it is focused on. Injunction. So getting an injunction for your client, because an injunction can give a quick relief to the IP owner, quick relief to the IP owner. Thereon, the injunction can be made permanent until the disposal of the suit, or it can be kept pending if the defendant can bring some contradictory, or it can get some documents to support his claim. And if there is no prima facie case, the court can vacate the injunction, make it not permanent, make the temporary injunction may not be granted until the case is disposed, and they'll move on with the trials. Issues will be framed before the court of law. Evidence will be led. Evidence in an IP litigation is quite different from evidence that is being, the procedure is the same. Yes, the burden of proof, what needs to be proved in a trademark infringement suit, I'll be discussing the defenses in detail. So the evidence is quite a interesting stage that we see in the process. Then comes the final arguments and the judgment. So these are the main stages that we see in an IP litigation in India. So moving on, the first, when we talk about cases, when we talk about litigations, the first thing that comes up is the jurisdiction. What is the jurisdiction? Where am I supposed to file a case? What is the process? Is it the place where the because like I mentioned, a lot of businesses happen all over in India. I might have a registered office in Bangalore, but my infringer might be placed in Gujarat. How can I take action against him? Finding a counsel in Gujarat and taking action locally there can be again quite cumbersome. So, what is the, how to go about with the jurisdiction? So, under the statutory provisions of Trademark Act, Copyright Act, the one of the privileges that a trademark registration can give you is, if you are a registered proprietor, then you can file a case at your place of business and not at the place of business of the defendant. You need not go and take action in Gujarat. You can take action in Bangalore itself against a person selling your products in Gujarat. So that is one of the benefits a trademark registration can get you. A registration is not mandatory. Trademark registration is not mandatory. Copyright registration is not mandatory. The prior use itself will give the IP user title. But however, design registrations and patent registrations are quite different. Patent registrations, at the quantum of law, the requirements are quite different between these laws. There is a quite difference there. So jurisdictions plays a big role, which is why all the startups or entities or individuals are suggested to go for IP protections, trademark filings, copyright filings prior hand, to give them the benefits that the statutory law has put forth in India. So while selecting the jurisdiction, if you have a certificate, it's very easy. If you can file a case in your place of law, in your place of business, where you're conducting business, you can easily prosecute there and get relief. Now, I'll, as we see more prominence and focus of trademark litigations and copyright litigations, these are some of the defenses I'll be specifically talking with these two, not the general IP litigation. Now, an infringement suit means, if I am a registered proprietor of a trademark, if I've got my trademark certificate from the trademark office controllers, and I can go ahead against my violators for a relief of infringement of my trademark if I'm not a registered proprietor, if I haven't got my trademark registered. So I think a lot of you might have observed in the market, if a product is being sold, they have this R and round symbol against their labels or logos or marks on the packets. I think this is something that is very common now. A lot of you might have observed. This R and round symbol indicates that that trademark has been registered with the trademark office. Otherwise, if it's just TM, meaning they have filed for that application and they're not registered proprietors yet. If it is registered, you can only then, only if you hold a valid and trademark certificate, you can go for the relief of infringement before the court. If you don't have that, you have to go for the relief of passing of action. In a passing off action is similar to a trademark infringement action. However, the things that you have to prove before the court, they have to prove there has to be an element of misrepresentation, apprehension of damage. There has to be an element of a person passing off his goods as your own. So these are some of the requirements the court of law will see, and you have to prove long and prior usage before the court. If you're going for a passing off action before the court, these are some of the things that you can prove. But it is much simpler to go for an infringement suit, because when you have a trademark certificate or if you have a copyright certificate, this acts as a prima facie title of right. It gives you a right to proceed against proceed against the violators. You don't have to prove before the court that it already is a prima facie title. Then the court will see certain tests. There are certain tests that is put forth by the court to see if there is an actual similarity between the marks, if there is a deceptive similarity. So visuality and phonetic tests are taken up. When you look at the product, is it similar? When you pronounce the trademarks label mark, how is it similar? So these are some as a whole. So the basic principle of law that the court will look at, it will take up two services or trade names or products, compare it as a whole. When two trademarks are compared as a whole, if there is any form of confusion arising out of it, that is when, in comparison of whole, a deceptive similarity will be established by court. To in the eyes of an average man with an average intelligence, so us as professionals might pick up infringement quite faster than an average man. So that is not the test that the courts will apply. The courts has to see through an eyes of a man. If he's passing through an aisle in the supermarket, if he looks up and he sees two products, in his first impression, if he sees that it is same, he picks it up. That is the test that the court adopts in a trademark infringement suit. So if I am an average man and I'm walking down the aisle and I look up at two products and I think, oh, that's the same red color, the same packet, it's similar in the pickup, although there might be two different things. So these are some of the similarities and the tests that the court adopts is on the first impression of an average man with an average intelligence. Is there a confusion or not? If there is a confusion, then there are probably chances of the trademark being violated. So that is how the courts will arrive at the conclusion. These are some of the tests that the courts have been time and again adopting in the courts of law around India. And then, what are the defenses that a defendant can adopt? Now, if someone comes in a trademark infringement case and says that I have been using this mark for quite some time and someone else has adopted it, now what are the defenses that can be adopted? So the defenses is, if he also is an honest and concurrent user from a very long time, like let's say there are two schools in Delhi, Guru Govind school, primary school, Guru Govind the English school, that have been running in the same vicinity of the area for more than 20 years, aware of each other's presence in the market. Now, one of the school might be have been established a bit earlier, and they would have had their trademark registration done, or there might be a dispute between the two schools that might have come up right now. So, one of the defenses that if it is prosecuted before the court of law, one of the defenses that the defendant can take is they have been honestly and concurrently been using that trademark for a very long time in the market. So this is one of some of the defenses that can be taken up along with something called a principle of acquiescence. Acquiescence is nothing but you being an IP owner, you are aware of another competitor in the market who is violating your brand. You have allowed that violator to continue his business, and then you have allowed that violator to invest in his business and grow for quite some time. Then after few years, when he becomes an actual threat, or if it starts harming your business, you cannot go to the court and say that, look, he is violating my trademark. When you allowed him to grow from a very small business, you're actively waived your rights, allowed him to invest in his business, and not just mere waivers. See, there might be a lot of violators in the market. The IP owner, it is not feasible to go against each and every IP violator and take action. It is not just a negligence to take action, it is knowingly, actively allowing the IP violators to grow in the market for a lot of considerable time. So, this active part is very important to prove up the principle of acquiescence. If this defense can be proved in the court of law, the defendants can say that you have waived your right to take action against me. So, one of the very strong defenses, a lot of evidence and burden has to be adduced to prove that before the court of law. Now, another defense that we can take up in a trademark infringement suit is a common to something called common to trade. Now, as common practice we have seen in India, a lot of businesses adopt surnames, names like New Grand, Ganesh BD. So these are like Saraswati, God names, names of gods, names of our sir, ancestors, places. So some of the common names are adopted for a lot of businesses, and they're run even today because they think that the customers can associate with them very easily, or they do not put much thought into branding their businesses. So what happens is these names might be very common to that particular trade. Now, if I'm selling shoes and I open a shoe mart saying that name it Shoe Mart Inc. Now, shoe is very common to the trade. If you look at the shoe apparels and shoe industry, shoe is a very common name. Now, I can't claim monopoly over this, even if the person has used it for a very long time. Now, he can't stop everyone else in that industry from using the term shoe. So, this is another form of defense that can be taken up by the defendant in a trademark infringement suit. Then prior user. Well, it's very important not just in the trademark infringement suits. If you are looking at any form of IP violations like copyright, if you are looking at patent or design, who is the first user? Like who adopted it first? Who invented it first? Whose original art, thought, or a copyright was it? That comes into picture. The prior usage of that particular asset has to be proved before the court. That title is a superior title in any form of litigation. Now, even if you've got some other person has got trademark registration certificate, it doesn't matter. Even if I have not registered my brand, but I've been using it first, if I can prove with sufficient documentary evidence, like my sales, invoices, bills, saying that I have been using it before you, then I still have a right over him. It has a superior title, it has a superior right. Another test, I think I already spoke about the test of deceptive similarity. That another test of deceptive similarity is, for instance, I go to the court and I have a brand name, a very common brand name, I believe, Adidas. Now, another person has Agidas. Agidas. He has adopted something called Agidas. It is not identical, but it is deceptively similar. If you're selling the same, if you're selling shoes itself again, it can be very closely, deceptively similar to each other. So this test is also adopted by the court. So when you're looking at trademark violations, it need not just be identical trademarks that is adopted. Even if you try to add new or grand and tweak that trademark, even to Nike, if you add neon Nike, and if someone else in the market starts launching shoes called neon Nike also, it can be violating because it is similarly deceptive to another proprietor. So this deceptive similarity is another test that is adopted by the court of law. So all of these laws you have to prove, you have to state, the burden is put on the, so the main burden will be on the person who goes to the court saying that my rights, IP rights have been violated. So when you go to the court, you have, it is the burden is upon you to prove your point before the court. The burden is not on the defendant. You can't just say that this is mine, he's violating it. You have a burden to discharge before the court of law, stating who you have to first prove your claim over it, title over it, how it is being violated. All the burden falls upon the plaintiff unless contrary defenses is being taken up like prior usage by the defendant. It is his burden then to prove before the court that I am using it before the plaintiff. That is how the burden shifts. The proof or the trial, during the phase of trial, the burden will shift between the plaintiff and the defendant. All of this will be taken into consideration by the court of law before passing the final verdict. Then there's also a thing called class of consumers that is very interesting in a trademark infringement suit. A class of consumers. So let us take, there was a case recently. Now, if we look at a very premium alcoholic beverages brands, like a premium whiskeys in the market, they're sold for a very high size. Even one bottle of a very expensive whiskey can go about for 45,000, 50,000, 60,000. Now, there was a case where a similar violator was there in the market and a case was filed before the court. He was selling it for 50 rupees, like very, very lower price, 1,000 rupees or 2,000 rupees compared to the premium brand. Now, when the case was filed against this violator, one of the points that the court of law looked was, who is your class of consumers? Now, the person who will buy a 50,000 bottle of whiskey will be well read, will anticipate, look at the brand thoroughly. His inspection of the brand or inspection of the goods before the purchase will be higher. The kind of class of consumers that this brand owner will have will be different to the other brand owner. So this distinction was drawn by the court, and the court observed that you'll have to see, if you're looking at a violation of a trademark, you'll have to see who the consumer is, what is the trade channel where it is being sold, who it is being sold to, who's the average man here, will be looked into to arrive at a standard. Will they be easily fooled? Because at the age old test that will stand in a trademark suit is there confusion or not? When you look at these two brands, will the average man be confused? Is there a confusion in the minds of the public? Only then the final satisfaction will be there for the relief. So there the court said that no, if a person is going to send 50,000, they will inspect the product and they will not be easily misled by this brand, is what the court decided. So I already discussed about the comparison and the nature of the commodity. So I'll just touch upon the Tribunal Reforms Act of 2021. It had a lot of impact on the IP scenario in India. Now, like I mentioned, a lot of IP litigation initially was focused in Delhi, focused in Mumbai. One of the main reasons why, because the Intellectual Property Appellate Board, IP board, were also placed here. Trademark offices, IP offices were also placed in these jurisdiction. Copyright offices is in Kolkata. So when it was jurisdiction centric, the practice also was revolving in these states. Now, what the Tribunal Reforms Act did was, it Intellectual Property Appellant Board was completely abolished, and the right was given for, if your trademark, you have got it registered and you want to appeal it or you want to challenge its validity, you can either go before the court of law, that is your high courts has jurisdiction now, any respective high court, or you can go to the registrar of the trademark office. Or so such, the function of IPAB was completely scrapped out and distributed among the offices of intellectual property rights and high courts. So what has happened with this change, now we can see in the litigation will increase in the IP field. Why? Because each state, each businesses can go and challenge the validity of registrations, everything in their own respective high courts. So I think this phase of change now we will be seeing in the coming years, where we'll be seeing an increase of litigation in the high courts of the respective states. So it will not be very limited to one state itself. It will be widespread now. A lot of opportunities and scopes will also open up to practitioners everywhere. Now, I think I can even speak about the moral rights. Is also one of the, when we look at the copyright law and the litigation in the copyright law, if you look at violations of musical rights, if you look at violations of literary rights, we see that there is a lot of economic disparity between the parties. Now, what when we look at the copyright violations, it will be either be between artists and big companies and the owners like music labels, or it will be between the publishing houses or mere artists. The capacity of a litigant when he's a small time artist is very less. His right in itself to litigate or substantiate or get his enforcement of rights is very difficult right now, because the person he is coming up against is equipped economically on a very high level. So when copyright litigation in India has a long way to go to give effective relief to the artists. But then again, when we look at the literary, if we look at the artistic works in labels of products, if you look at the packagings, artistic work that exists in packaging and everything, businessmen are taking it very seriously, because we know that the brand name alone is not will not substantiate one product. The packaging or the trade dress of the product is also very attractive to the common man or the seller. So I can name it anything. If I still retain the original label of the another owner, I can still get a lot of customers. There is a scope of violation of copyright, a lot of scope of violation of copyright here also. So when we look at these, a lot of cases here also has been coming up. Now, trademark and copyright, one more thing is there's something called a concept of composite suit that we can file before the court. Now, sometimes I have a now if I'm have a violation of a packaging of my phone, now the brand name will also be involved, and the phone also, the packaging of the phone will have artistic work, that is a copyright in that as well. So both can be violated at the same time. So what do? You can club both the reliefs. You can ask for the relief of infringement of your trademark, you can ask for the relief of infringement of your copyright, and you can file a composite suit. In fact, even passing off action relief can be done, and it is held to be valid in the courts of law. It is very common practice currently, because the circumstances and the issues involved in answering these questions of laws and facts is quite similar. So the suits can be held, can be maintained together. So all these reliefs are usually composed in one suit and filed. Trademark infringement, copyright infringement usually go hand in hand, and composite suits are filed in the courts of law. Again, like I mentioned, the trademark registration is no guarantee of title. It is the prior user in the market who has a superior title over a trademark. I have pulled up few case laws, few from copyright, few disputes of design and infringement. I'll be dealing with them one by one. So this is a famous case of Glucon D versus Glucose D. The two very big companies had a tussle few years ago. That is, Heinz Italia had filed a case against Dabur India for the use of this deceptive similar trade dress. As you can see, the packaging of both the products here, the green color is similar, very dominant, and the happy family picture that they have input in the center of the packaging is also very similar. So, a case was filed by Heinz Italia against Dabur India, stating that we have been using this packaging and the trade dress from a very long time. This is the first one of the first times the court considered the concept of trade dress. That is not just the name Glucon D and Glucose D is similar, but the packaging also is deceptively similar. So this is called a trade dress. So this concept was analyzed by the court of law in this case, and they say that we are of the opinion that the packaging of glucose D is in glucon D is so similar that it can be it can easily confuse a purchaser. This was what they held, that it is deceptively similar, the packaging. Now, another interesting Supreme Court judgment is Nandini Deluxe versus Karnataka Cooperative Milk Producers Federation. In the state of Karnataka, There is a very famous restaurant chain called Nandini. They sell vegetarian food. It's a vegetarian and non-vegetarian restaurant services called Nandini Deluxe. Simultaneously, we are talking about very old companies. That is on. We're talking about companies that has been established more than 30 years in the state of Karnataka. There is another government federation called Karnataka Cooperative Milk Producers Federation, which sells milk and milk products only, called Nandini. Now, what happened was both of these, that is the food products and the restaurant services, initially have kind of similar, they fall in the similar classification. All of you, I think, are aware that when we look at any violation, like I mentioned, trademark violation specifically, we see which trade channel, which service they fall into. Unless you are a very well known brand, you can't say that no one else can use that in any service or any goods, that particular brand. Only a very well known brand can stop. Like if we, for India, if you look at Tata brand, it is so well known that if someone else adopts Tata for any sale of anything also, it becomes a violation. But again, if I'm a very small time brand, if I'm just selling gadgets and laptops and someone else is selling something else altogether in a similar brand, I cannot, the customers usually might not get confused. So for this purpose, there is an international classification called NICE classification, wherein there are about 45 to 48 services and goods classifications that they have made. For instance, classification 5 is for sale of pharmaceutical products. Classification 42 is for 45 is providing legal services. So the main categorization of each service and goods have been made by the NICE classification, which is followed in India currently. Now, what happened in this case was, in this broad classification, there might be different things that is involved. So the court said that just because you are registered in one particular classification, you can't have monopoly over all the services and goods that fall under that classification. This is one of the landmark judgment. So they said that Nandini Deluxe is just restaurant services, and you, Nandini, are only selling milk and milk products. So there is no confusion between the products as long as you limit to your services. There will be a clash only if you enter the restaurant services or they enter the milk and milk product services, which they have not been. For several decades, they have been functioning in only that sphere. So in this practice, the court ensured that one brand owner will not squat and create monopoly in all the different kinds of classification, different kinds of goods or services that falls in one particular classification or trade channel. But even the courts will observe to see if we are looking at allopathy products or homeopathy pharmaceutical products, there might still be confusion. So they are called allied uh, products. So all of this the court has to take into consideration. So the main principle of law here, the court said that since they're only restricted to restaurant services and you are restricted to selling of milk and milk products, you can't claim monopoly over everything, is what the court observed. And I put up a very recent case. Now, the litigation practice, especially in IP, is taking another turn where a lot of businesses might not have credible claim against the violator, or they might not have any case, but they're forming a habit of filing frivolous cases against businesses to create unfair market or competition or monopoly, unfair trade practices. They're taking advantage of filing these IP suits to make sure they curb their competitors. This trend, this alarming trend, is being observed by the court, and I think it's a very interesting case called Giant Industries versus Indian Tobacco Company, where the court observed, I'll just read it out. The facts of the present case, the conduct of the plaintiff is reprehensible to say the least. As mentioned earlier, she has approached this court not only with a false case and on the basis of dubious documents, but also lied to the court. I have no hesitation in saying that the claims made in the above suit are wholly frivolous. Though the plaintiff does not deserve any sympathy of this court, consider the plaintiff is a lady who is approximately 34 years old, purely out of mercy. The court awarded a cost of rupees 60 lakh to be paid by the plaintiff to the defendant for filing a frivolous IP infringement suit. So, such decisions are being taken up by the courts now. I think this is the Bombay High Court to pass this order. So make sure, because when we look at IP, a lot of commercial interests and unfair trade practices can come into, like, IP rights are in itself very monopolistic in nature. If I am an IP owner, I will have monopoly in the market already, which has a lot of debate going on in the market. Now, when such businesses or and when such individuals try to take advantage of it and file frivolous suits to make sure that the other person's business is harmed, because when you get in, like I said, how effective an injunction order can be, it can bankrupt a business. So when such reliefs are sought before the court, you have to be very very careful. False and frivolous cases are being fined this way by the court, and I think it's a very good precedent that the court is setting up to make sure that advantage is not taken there. In case of there already exists some monopoly, such dangerous precedent should not come forward. Moving on, I think I just have very few minutes left, two cases, and I'll wrap this up. See, the litigation is very
Ma'am, I'm so sorry
exhaustive.
to interrupt. Hello.
Yes, please.
Ma'am, actually, just to confirm, which slide are you on currently? Yes, yes. Because the slide were stuck on slide 4, your PPT.
Okay, this is the
Yes, ma'am.
slide. Is it visible?
Yes, ma'am, it is.
I'm changing. Shri Ganesh Basin Mill is now it's visible, is it? This case, slide number 9.
Yes, ma'am. Yes, ma'am. Now it's ready.
Yeah. So, see, it's very exhaustive. I'll not be able to cover up in a session of 1 hour, but all I'm trying to give you a practical idea. Like, academically, you will be exposed to a lot of theories, a lot of case laws, but practically, how does it happen in court? Even if I get an injunction, sometimes I'll not be able to get that relief. Even if court gives me an order against the defendant to stop using it, what these violators do is, there's one form of trend that happens in the market now. They stop giving bills and evidences and they start selling it just hand to hand in the market. So for us, it will be very hard to get evidence before the court to show that, he's still violating, he's still continue to violate. So which is why different forms of orders are being come up. Oh, also, there will be this concept of, put up a shop, sell, pick up the shop, go somewhere else and sell it. If you're looking at market cluster marketplaces like Sarojini Market and all these national markets that is very famous all over India, to see that a lot of counterfeit products are being sold in such places, and a lot of actions are being continuously taken. But you take an action against them, they don't have any registrations, they're not companies, they just wrap up and pick up that shop and go set up elsewhere. So it becomes very exhaustive to take action against these people. So even practically, if I get an order from court, sometimes I'll not be able to give that relief to my client. So these are some of the challenges we face. Now, also, as I mentioned, the actions are taken in district court, especially in Karnataka. Here, I'll be going to a district court and filing the cases before a district judge. Sometimes the judges are hesitant to give us bold orders. Whereas, similarly, if I have in a forum of High Court, I might be getting bolder orders from the Court of Law for effective enforcement of my intellectual property rights. So, these are some of the practical challenges we see in the field of litigation. Just another case, and I think my time is up, correct? Pritesh?
Yes, ma'am. Yes, ma'am.
I'll wrap it up with this one case, or we'll give some time for Q&A.
Yes, ma'am. We will give some time for Q&A.
Just one this case, and I'll wrap it up. Hey,
Sure.
one more thing I mentioned, this is very common practice in India to adopt very common lakes like Ganesh Basin, Ganesh, names of gods. So this is one such other case, a very recent 2021 Calcutta High Court. So Ganesh Basin Mill had filed a case against Ganesh Grains Limited. They had got themselves registered. The trademark certificate was there with the plaintiff. But the court said that as the word mark Ganesh is very common to the float trade, generic, non-distinctive, and moreover, as it is a name of a very popularly worshipped god, the registration of the mark is invalid. The court held that invalid, but however, relief was given to the plaintiff because the packaging was the label and the similarity was there with, and under the action of passing off because of those similarities, relief was given. But prima facie, the court held that the registration was not valid. So just because you get a trademark registration sometimes doesn't mean that you have the right over it. You have to be very thorough about the law. It can be held invalid later by the courts. So, with this, I would like to wrap up my session, and I hope I gave a little insight as to how cases happen, what is the current scenario, challenges, defenses that we face in the court of law today, especially in an IP litigation. And if you have any questions, please.
Thank you, ma'am, for the session. It was indeed a very interesting one, and each and every participant, as well as me, for the matter, has learned a lot during this session. Now, before this session, we shared among students a Google form wherein they put in their own query which they wanted resolved during after this particular session. So I'll start with the very first question. The first one
Yes.
is, ma'am, for obvious reasons, in India we are accustomed to a system which takes years at times to deliver justice to those seeking the same. So, with regards to IPR dispute, is there any statutory provision which puts a bar with regards to how fast the same should be resolved by the concerned court? That yes, okay, there is a particular case of IPR dispute related having a statutory limit of 10 lakh or 20 lakh. We have to resolve it within a time span of 2 months. The concerned court has to deliver its judgment within a time span of 2 months. Is there any provision related to that?
Huh. So currently now courts are realizing that IP intellectual property dispute is a commercial dispute. I think a few of you will be aware now. Everywhere commercial courts are being set up. You know, as lower as district courts also now commercial courts are being set up everywhere. Where here in Karnataka, if punitive damages are sought beyond 3 lakhs, initially commercial litigation was limited to 1 crore. Only then an IP damages, if you were seeking beyond 1 crore, it used to come under the ambit of commercial litigation. Commercial litigation have provisions like speedy summary disputes, summary judgments, speedy trials. So there are a lot of provisions set up in the commercial disputes procedures and laws, statutory provisions to ensure that the case gets disposed early on. But what happened was because of the pecuniary value was 1 crore, a lot of IP disputes never came under the ambit of commercial disputes. So it was not widespread, the practice. Recently, they made an amendment and lowered the valuation to as much as 3 lakhs now. And also, they're setting up commercial courts in all rural districts also. Small districts also commercial establishments or courts are being set up. Initially it was only in Bangalore commercial courts was there, not in other states and districts. Now everywhere commercial courts are being set up. The system is being changed. Now the pecuniary jurisdiction having been reduced to 3 lakhs, if you claim damages more than 3 lakhs in IP cases, you can go ahead and uh, file it as a commercial suit. Therein you have a lot of provisions which provides for summary judgment. If there is a clear case, you can ask for a summary judgment which has to be disposed within a month. So a lot of speedy options and disposals are available right now. The time, the process, the wheels of change has been set, and it will take time for it to be implemented.
So it is yet to extend up to all the districts, but
Yes.
selective districts likewise in each state, like even in the Jharkhand now, 4 5 districts are provided because where the quantum of these commercial disputes are high, in
Hmm.
that criteria they situated, and for those local means the jurisdictions like cyber commissionerates were situated on 4 5 locations. Like Jharkhand is having 7 locations where the what is that area where cyber crimes happen more, Pritesh?
Jamtara, sir. Jamtara,
Ha,
sir.
Jamtada. Yes, Jamtada is a remote area. It is a adjoining center of what is that Bangladesh? What is the next state? Calcutta, West Bengal, and Nepal. Yes, that connecting area. That's the reason where, because of this reason, one cyber commissionerate situated in Jamtada for the scope of that litigation, cyber litigations cropping up. Similar way for commercial disputes also, where all the commercial disputes growing, those districts are selecting, giving the surrounding districts of that jurisdiction to that. And in that way, in the name of commissionerates, they were allocated. These commercial courts also like that regional wise now provided. It is going to be expanded till each district level. By then, it will be available at every jurisdiction.
Yeah. So some, and also like I said, like very few cases actually even go into trial, IP cases, because at the stage of injunction itself, it is so effective that it gets decided whether the person is going to. If you are already got a injunction until the disposal of the suit that the person should not run that business with that particular name, you pretty much stop that business. Or if your IPs or your literature work or your copyright is being violated, you can completely stop the sale of that. So the defendant also stops violating those rights. Effectively, in the stage of injunction itself, most of the IP litigation is sorted out, settled out of the court. Very few, in fact, go into the phase of trial, that is for the stage of evidence.
Okay.
Along with that, a quick remedy also available in commercial court,
Huh,
because
yes.
in comparison with regular court takes time to understand and expertization uh, requirement, but whereas these commercial courts are bit capable enough to deal with as early as possible. So that's why commercial courts able to provide the remedy early, and litigants also now learning the platform properly and taking a wise decision rather than expanding the litigation and stucking in that difficulty.
Okay, sir. Thank you, ma'am. Thank you, sir. Ma'am, the second question that we have today with us is recently Intellectual Property Appellate Board was scrapped by virtue of Tribunal Reforms Ordinance 2021. Now, due
Yes.
to this, all the cases pending before these IPABs has been transferred to the respective High Court. Delhi High
Yes.
Court in particular has formed a separate IP division
The
to deal
rules
with
and
IP.
regulation have been set up by them. Yes.
Yes, ma'am. I believe that it's Justice Pratibha M. Singh who is leading the same.
Yes.
Uh, as a
She.
practitioner yourself, since you have been practicing in the field related to intellectual property rights, what is your opinion about this step by the government? And do you think it's the correct one? Will it provide impetus toward making India as a IP hub? Considering toward making ease of business in India, it is very essential that the judicial system should also walk side by side with the government at the same time.
Yeah. See, I think this was so important that I touched upon this in my session today. Although it was not required, but I specifically touched upon the Reforms Act. What is the practice in India? Why it is only very jurisdiction center in Delhi, Mumbai, Kolkata? All these places alone had a lot of cases. Even if we look at the reported judgments currently in the all of these jurisdiction cases only keep popping up. So why is that? Was intellectual property appellant board, trademark offices, all of them were only situated in these jurisdictions. So if I am from a small town in Ranchi and I have a business here and I have to file a trademark registration and someone else is selling in some other place and I want to take action against him, I'll have to go all the way to intellectual property appellant board that has a setup in Delhi, put my case forward, find the bear the cost of litigation, which will be very high compared if I just do it in my jurisdiction. Correct. So this this change was brought about by, it was a brilliant move when it scrapped intellectual property appellant board. There were a lot of reasons for the scrapping of the tribunal, but when a tribunal that was not providing accessibility to, see, IP owners are there all over in India, not just businessmen are there in Delhi or Gujarat or Ahmedabad or Mumbai. There are businessmen, there are IP owners all over India. This made sure that accessibility was given to them to enforce their rights and to protect their rights, to secure themselves very well in their jurisdictions. It made it widespread. So enforcement will become more easy now. IP violators can it will become very cost effective for now for them. People who were hesitant to take up these actions, we all know that IP can be quite expensive endeavor already. When this was being taken out, this is one of the advantages now. A lot of IP owners can go to their respective jurisdiction, their high courts, and get the reliefs quickly and more efficiently. But this has also been a con that a lot of experts in the field are saying that the tribunal forums, the presiding officers over there were much more knowledgeable than the justices that will have the exposure. Here is one of the con, that is the technical expertise we saw in the forums will be lacking. Here is one of the cons that is being discussed in the industry. But however, I think it is a brilliant move. It will provide more accessibility to IP owners to secure their IP all over India, and it will not be just limited to few states alone.
See, in that
Digitally
way,
now,
yes, she's right. As per the expansion of the scope, it is good.
yes,
But while expanding the scope, this expertise part, which is pointing out by the industry, is a very required point to be addressed by the state. And Government of India also mentioned that we are not ignoring that. We are going to set up that arrangement as well. At every high court level, one tribunal, like now we have labor tribunal at every level. So every state, these kind of common subjects, their availability is possible, but expertise, human resource availability in this field is bit limited. So that's why, according to the availability, we are going to make the alternative arrangements in a form at state level. At every high court level, a tribunal will be definitely feasible and facilitatable. So that is also at the subsequent, I think in next coming period, we will see those line of changes as well. There was
yes,
no absolute wade off or means no evading that system. They are replacing it with, but it will take some time. In the meantime, the scope was expanded. By that way, we can also test that if you leave it like that, how much of variation is happening and what level of tribunal setup is required. That will be definitely built. This is my expectation and understanding
yes.
of the current work. Yes, any other
Thank you, sir.
questions?
Thank you, ma'am. There is one more question. Ma'am, this question comes from a second year student who is asking, I am interested in intellectual property law and want to further my career in the same. Hence, as a professional who was once in my own shoe, that is you, ma'am, yourself, what do you suggest that I do in order to ensure that I am placed in a decent firm with strong IP practice by the end of my law school? I believe this student is one of your own juniors from your own university. He
Okay.
studies
No,
at NUSRL
there
Ranchi.
is no hard and fast rule to follow. Like first and foremost, keep up the passion of IP. Be very active in the field. Be aware of what the laws is. It's a very dynamic field. Now, every day, that as and when the technology and entrepreneurship keeps developing, IP also keeps changing, and new laws keep coming up. They keep framing to adopt the pace of the technology. So it is always advisable to be updated. Try as much as possible to be involved in the activities, the forums, events that keep happening. Try to gain internships in the field of intellectual property rights. See how practically it happens. So when you are in touch with the field, when as and when an opportunity will come up, you will have a front hold to grab hold of that opportunity. You'll never know when you get the opportunity. Stay in touch with the field. Be very active in it. Would be my suggestion.
Okay, thank you,
Right.
ma'am. Ma'am, there is one
Okay.
last question that we have, sir. Right before the session, you and ma'am were talking about LLM, and one of our senior students was asked a question with regards to LLM that I want to pursue IP litigation. However, I am not sure whether to go ahead with IP litigation right away as a practitioner after my law school, that is after my BLLB from the university, or pursue my masters from abroad first. Moreover, if I decide to go for masters, should I go for masters from abroad or should I pursue my LLM from a national law university itself?
Yeah, that's it. Okay. A degree like intellectual masters from uh, abroad has its advantages. What advantages is that you can network on a worldwide basis, wherein people from all over the continent, where the various different continents would have come. You can network with them. You can see, get a worldwide perspective on the intellectual property rights. You will not be limited to one jurisdiction, but we all know that if you are focusing on litigation, it is very jurisdictional. All the rights, all of the enforcements is very jurisdictional. So it will not add value to the practice per se, but in the point of view of getting a wider perspective and networking, that is a good option. But if you have the opportunity, I suggest go ahead, complete it. Okay, but taking unnecessary risks go there, additional expenses and debts will not be recommended. Rather, you can stay back, pursue it from our now, national law universities or even IITs offer prestigious courses. Even they are academically, they're up to the mark. You can also pursue it here. There is not much difference there. Only thing that leg up you will get there is the networking. You can also be exposed to their form of practice, litigation. But with this accessibility, there is not much difference. If you come back to India, if you want to pursue IP litigation here itself, if you can bear it, you can go ahead and do the costs and everything if it will not put set you back. Otherwise, I suggest you pursue LLM here, come back, practice here itself. In fact,
Thank
I
you,
think a lot
ma'am.
of IITs are also offering prestigious master courses and diploma courses in the field
Yes,
of
ma'am. I think IIT
IP.
Kharagpur is offering one. Rajiv
Yes,
Gandhi School of Law.
they're also offering. So you can choose it and do it. There's no issue with that.
Okay, ma'am. Thank you, ma'am.
Equally
Thank you,
valid.
sir. Okay,
So
ma'am.
is it
Thank you,
done
ma'am.
with questions?
Yes, sir. Now, before proceeding with the session, I coming to the end, I will request our faculty in charge, Dr. Srinivas Murthy, to present his remark on the session. Sir, please.
Right. Right. See, thank you, Miss Akshata Patel.
Thank you.
So, for sharing your experiences to our upcoming students and the current studying students who are interested in IPR. So, this message will give them the orientation of looking into the subject and how to go ahead with the subject learning and observation. One point. And second thing, few of the landmark cases you picked up, and by the same time, the recent cases, how the litigation scope is evolving. So that with practical explanation you provided, the dimension of the litigation looking perspective was described is a very good thing for the students who are interested in IP learning. So that will be helpful not only for going into litigation alone, that will be helpful even looking into the subject in wider spectrum. So by understanding the subject in all dimensions, so this perspective is necessary because strategies are working basing on the confrontation condition. So now what is the dynamics of the subject working in the practical world? Understanding will give the academic learning of the subject in a better manner. So that way your lecture is beneficial for academicians or academic oriented study people also. Other than anyhow your lecture is directly beneficial for litigation oriented purpose, that is directly beneficial. You gave this angle of learning the litigation handling skills, so it is very useful. In that way the perception is, yes, this is the preliminary viewpoint, it is not the whole and total understanding of it, but yes, in this given 1 hour very crisply and focally provided the input for looking into this understanding is a very learned exercise. Like for 3 4 years of her working, whatever she learned she able to keep in this 1 hour and provide the benefit. This is how a upcoming student can gain out of 3 years effort. You able to listen from her for 1 hour, and by that way you can develop your betterment of your hours of usage. So is one benefit out of this exercise, I believe. And that way I'm very much thankful we gave 1 week before to go up with this exercise, and within this short time she able to make up her experience in a summarized way and provide it to the benefit of our upcoming students as a social responsibility by Miss Akshata Patel is a remarkable job, and I will be very much thankful, and we try to utilize her expertise now and then frequently after this. So on a specifics, like now today we take her service in a general thing. So hereafter we will try to go with a specific, like she will be experiencing different cases and contest. So in that way, in a specific context, if we are able to utilize, that will be more helpful. This is my observation out of this lecture, and I am once again very much thankful for your contribution.
Thank you so much, sir.
Thank you, sir. Sir, and I will request our student convener, Mr. Harshal Bhale, to present the vote of thanks.
Right.
Right. Thank you, Pritesh. First of all, I would like to start by saying that intellectual property right is the oil for the 21st century. And now, and on these grounds, the Center for Study and Research in IPR, it is one of the prominent center in National University of Study and Research in Law, Ranchi. This committee has founded on. So. Since the creation of this committee, that was back in 2011, the Center for Study and Research in IPR, that is CSRIPR, uh, uh, has been involved in organizing many events such as webinars, seminars. We have organized a lot of events based on which will give direct benefits to the students, to the IP aspirant, and the not only the law student but also students from science and engineering backgrounds. So that is something which is really important. Now today, till now, I'm getting a lot of questions from the students also, but due to time crunch, we won't be able to cover all the questions. So what we'll do is you guys send us the question on our CSRIPR email ID, or we have our social media handles. You can ask us their questions. You can ask your questions there, and then we will try our endeavor to reply you as soon as possible. Now, with respect to the today's program, I would like to give a huge thanks to Miss Akshata Patel, ma'am, and for taking out your time in this busy schedule and coming on here and giving the lecture on this very important topic uh, of intellectual property rights. Then I would like to thank Dr. Srinivas Murthy sir and Shamla ma'am for being there every time we need to organize any event that we are organizing. Then the host of today's webinar, that is Mr. Pritesh Raj. He is a third year student and IP aspirant plus secretary of CSRIPR. I would like to thank him for organizing such an great event. Plus the organizing team of CSRIPR. I would like to take few names of the people who have been throughout the process of organizing this webinar. That is Miss Anjali Jenas. Then Preetham, we have Pratham. There are a lot of people who have worked really hard to make sure that every program that we conduct, uh, you know, uh, every program that we conduct is a successful one. So, and lastly, I would like to thank the audience that are there. Not only law students but also students from engineering and science background who took out their time and listened to the entire webinar that we have conducted today. And yeah, this is how the seminar ends. If you guys have any question, you can ask Akshata ma'am on her LinkedIn, or you can type your question on CSRIPR mail ID. We will try our endeavor to answer your question. So with this, I would like to end this session. Thank you, everyone. Have a good day.
Thank you.
Thank you, ma'am.
Thank you,
Thank you,
sir.
ma'am.
Right. Welcome, madam. So, Miss Akshita,
Yes,
nowadays
sir.
we are getting so much of science students, like engineering
Huh.
and medicine students are getting in our internship regularly.
Okay,
Offline
huh.
internship, after online internship developed, we are getting the science students much. And
Okay.
some institutions are running BTech LLB or BSc LLB. Those students are also coming more. So that way
So
we are trying.
patent, I think their focus will be most on the patent
Patents.
laws.
Yes, yes, yes.
Patent laws. It is going to blow up in a decade or something in India. It
Uh-huh.
is going to blow up. As we've seen in other places, it's still not, we haven't even touched a fraction of IP laws enforcement or protection we have seen in other countries.
So patent litigation count is very low. I think
Very low.
gradually now it is going to grow a lot.
Registrations grants is increasing slowly now
Ha, ha, ha.
because a lot
It's
even
already from
institutions.
see 1,000 to now it reached to 20,000 of grant and
Yes, yes,
40,
yes.
45,000 applications receiving is now increased.
Receiving
And
this.
now there is a strategic development is happening. The increase of grant will be increased, like 50% we are granting, where we compare with other countries, there it is 70%, 80% granting. So there is a variation in granting. A stringent assessment is going on where that need
Our
to be
process and
relooked.
assessments, yes. It's
So
more
that
complex.
relook conditions are going ahead. If those things are improved and the grant level increased, I will definitely foresee that in next 5 to 10 years, the quantum of litigation will be definitely increased by 100%.
Yes, because valuation will increase, and also like with the government's initiatives like Make in India, they're pushing for entrepreneurs,
Yes, yes,
inventors.
yes.
Even institutions now are encouraging their academicians to come up with researchers. They're filing patent applications.
No, now
The
organizations
filings
also
of
widely working
institutions
like
has increased a lot, sir.
National Research
Patent
Development
applications.
Corporation. All these things are assisting to go ahead and
Yes.
complete the research and make out the registration. So that
Yes,
way,
sir. They're giving, yeah, they're trying to make these R&D into a commercial aspect. Like they're giving
yes,
commercial value to these research. That was initially for a professor doing a research and publishing a paper in a prestigious publication was sufficient for them. Now they're realizing the commercial value added to these research. They're understanding in those aspects. R&D is being invested by the universities and institutions itself. They're filing for patent applications a lot. It has increased now. It has and even entrepreneurs are going for, if they have any inventions that have industrial applications, they're trying to come up for patent protection now. So
even from
there
the
is a trend.
prosecution side also, Government of India is helping through what is this MSME by establishing facilitation centers and incubation centers where
Yes, I have been a
technology
part of
and
it, sir.
law put together and bring up into the protection.
Yes, I have been a part of it, and they're also giving refund for domestic applications. At least up to until 25,000, a refund is being given after grant, and
We are
even
also trying
startup
a
cells.
facilitation center in Ranchi, but because of slow growth and mild growing conditions here, so it is taking time.
Okay, they
Maybe
are,
in a
yes.
period of time, we'll get a facilitation center to NUSRL.
That will be beneficial to a lot of innovators there in locally, sir. That will actually be, because they're doing wonderful job here in Karnataka. They're setting up IP cells in all engineering colleges. They're encouraging them very young. They're creating awareness also. Because there is first a lack of awareness, so they're playing a huge role in creating awareness. They're also helping a lot of innovators to assist in their patent filing, drafting, in all the process until the grant.
Right. Thank you, madam. We'll take
Right.
it.
Thank you so much.
Thank you, sir. Thank you, guys.
Thank you,
So
ma'am.
I'm ending the broadcast now. Yes. Pritesh, we are ending the broadcast now.
Okay.